Okay, so welcome to webinar number 1 for 19, how old am I? For 2024. I'm really pleased to be back with you all, and I look forward to continue to provide you with useful information and guidance around the multitude of employment-related issues that all employers in the country now face, but which horticulture employers face in particular due to the particular nature of our workforces and our industry. So hopefully we'll be able to provide some useful tips and ideas for moving forward. I guess this year, what I really wanted to do, I want to use today to kind of recap a little bit on last year's activities. When I look back at 2022 and 23, they were frankly huge, and no one would know this better than you guys. But that steady stream of, amendments to the Fair Work Act and amendments to the Work Health and Safety Act just continued unabated. And many of these already adding to the already high costs of employment for our growers. So I want to just revisit a few of those changes today. We may not like them, but they are in place. And I just want to make sure that we're on top of those things that we needed to do over the past 12 months. So let's look also at what's coming. Yeah, it's not over yet, sorry. So I just want to also run a few reminders about some of those topics that we covered in 23 in the webinars so that we can just checklist some of those actions as well. Also, Fair Farms is undergoing some changes in 24, and not the least of which will be our new website, so hold tight. It will be coming sometime in March, and I'll speak about those towards the end of the webinar. So why don't we kick off? And as I said, these are largely reminders. Now, firstly, obviously, what we do is acknowledge the stories, traditions and living cultures of our First Nations peoples and the lands on which we meet today. We recognise the connection to land and environment and celebrate their care for country for over 60,000 years. We pay our respects to elders past and present and emerging, and we value their skills and knowledge as our first horticulturalists. Okay, so you may or may not remember, everybody's trying to forget. Over 2022 and 23, there were 3 tranches of amendments to the Fair Work Act. The first one was called Secure Jobs and Better Pay. The second, Protecting Worker Entitlements, and the third, Closing Loopholes, which then turned into Closing Loopholes Stage 1 and Closing Loopholes Stage 2. The latter stage will be taking place from February this year. Now, businesses and other stakeholders were all invited, governments, etc., to comment, but it was clear, I think, given the kind of political environment, that the majority of those changes would be passed, at least with the support of the Greens and Independents, and that in fact turned out to be the case. So just revisiting a couple of these, I'm not going into any great detail. We can go back and have a look at some of our webinars from last year if we need to revisit these in more detail. But first cab off the rank were a set of amendments relating to these things here on the screen. So the biggest issues in this tranche related to the introduction of paid domestic violence leave for all workers, and you'll recall that came as something of a surprise because it went from 5 days of non-paid leave to 10 days of full paid leave. So we'll be talking about ensuring that we have that in place. And the other thing, of course, was changes to the enterprise bargaining system. So all of those people have had enterprise agreements in place since, 2006, 7 and even years earlier. Those obviously came to an end on the 6th of December last year. Many people would have reverted automatically to the award. Some people went ahead and made new agreements. It remains to be seen how those are working out. There was also a positive duty to prevent sexual harassment. So it's not just a reactive provision now, it is a preventative provision, and some things around fixed term contracts. So in terms of the actions around that particular tranche of amendments, we ask people to go back and review sexual harassment policies and procedures. If you don't have them, to make sure that you've got them in place. So it's about making a statement about this positive duty, and also obviously about providing training to your managers and your staff on the purpose and the operation of that policy and those procedures. So effectively, you are making a positive statement. We have zero tolerance. We will take complaints seriously, and here are the procedures for dealing with these complaints, including concerns around or considerations around privacy and the like. We suggested with the changes to the provisions around fixed term contracts that if you were working with fixed term contracts for, some of your senior staff, just to ensure that you understand that there are now limitations on the use of those contracts where work continues. So if work looks like it's going to continue for more than 2 years, or you've had an employee on a 1-year contract for 2 years, 2 1-year contracts, then there are now limits applying to those contracts, and you may look at converting those positions to permanent ongoing positions. As we said, we got the family domestic violence leave policy in place. So make sure that you either refer to the NES for those provisions and national employment standards, and either have a policy in place and do some training, again, particularly with your managers and supervisors around what that policy says, what it means, and how you will implement it, and particularly around the privacy concerns. There are some fairly stiff privacy issues around the use of this leave and ensuring that confidentiality is maintained. Familiarise yourself with the various flexible work arrangements available under the Horticulture Award and the NES, and particularly around flexibility around parental leave and flexibility again around the ability to take this paid domestic violence leave. And again, if you had agreements in place, ensure that if you've converted across to the award, that you understand every provision of that award and you're complying with that. Or if you're obviously seeking to make a new agreement, our best advice is to seek professional help with that. Okay, the second tranche that came about, probably in the middle of the year, was called Protecting Worker Entitlements. And as that name suggests, that was pretty much what it was about. So it was about inserting the superannuation contributions into the NES. So they exist now in 2 pieces of legislation. Improve the flexibility of the unpaid parental leave. There was some issues around payroll deductions, and then protections for migrant workers. So from both the first and second tranches, some of those changes took effect immediately, some by the 1st of July and some at the end of 2023. So looking at actions around those particular ones, because this amendment to the Act inserted a right to superannuation for all workers in the National Employment Standards, you just want to review your superannuation and make sure that you're up to date. So it should be 11%. That'll be going up again in July. And remember that the changes included no minimum earnings, so that superannuation is now payable on all wages paid to all employees. So that monthly minimum of $450, I think it was a month, has been scrapped. Employees can now take up to 100 days of that 12-month unpaid parental leave provision flexibly, and that includes single days. So they may want to take a couple of weeks in the beginning, or they may want to take a couple of weeks in the middle, or they may want to take various days, like they may want to work a 4-day week. So if you have some of your workers in those situations, consult the National Employment Standards, familiarise yourself with those provisions, and particularly this flexibility that is now available. There was some issues around salary deductions, and the key to this is just making sure that they're all written and authorised deductions by the employee. So apart from things like taxation, superannuation, which are covered by legislation, and instructions from, for example, Child Support Agency for garnishing of wages, every other deduction needs to be for the employee's benefit, principally, and authorised via written authorisation and assigned authorisation. So make sure that if you are deducting monies, and they can be changed around, so they can vary from time to time. And also just confirming that if you discover inadvertently you have some employees on your workplace who do not have legal eligibility to work, so they haven't got a proper visa. Despite the fact that they don't have a proper visa, you still need to pay them for all work that they have undertaken. So make sure, you check the visa status of all your workers through the Vivo online mechanism, or ensure that you are provided with that confirmation through your labour hire provider. And remember that if you do discover somebody without a proper visa, you are nonetheless legally obliged to pay them for the work that they have done. Okay, so we then move to the closing loopholes legislation, which was announced, I don't know, about September, I guess, last year. This was initially going to be the government sought to pass it in one big basket. There was some fairly serious concerns raised about a number of elements of that legislation. And so with the support of the Greens and the crossbench Senators Pocock and Lambie, the legislation was in fact split into two parts. So the first part was passed on the 23rd of December last year, and many of those things have either come into effect or will come into effect during this year. The second part of the closing the loopholes bill will be debated, I think, in February, in a sitting of Parliament, so it's not yet passed, but it is coming. So let's have a little look at stage one. These are things that were passed in December of 2023. There are some stronger protections against discrimination. So that is adverse action and harassment around employees who may need to access particularly that family domestic violence leave. So employers cannot take adverse action against employees seeking to access their entitlement, their legal entitlement under those provisions. So again, when you're doing the training around this leave with your managers and supervisors, just make sure they understand that you cannot be taking any kind of negative or adverse action or harassing employees who seek to use this leave. Read those provisions and make sure you understand what's required. Oops, I beg your pardon, I do that again. That hasn't stopped from last year, has it? There's some stuff around small business redundancy in insolvency situations. Fair Work Commission now has conciliation rights in conference orders, Fair Work Commission now has rights to make decisions in conciliation conferences, so to make orders. Otherwise, previously those things had to be agreed. The Fair Work Commission, if the parties agree, can actually make those orders out of a conciliation conference. There's some relaxed entry permit rules around health and safety representatives. That's on-site health and safety representatives, so worker employee representatives. And we talked last year about the industrial manslaughter legislation that has now been passed as part of this bill. So that carries some very, very serious penalties in regards to industrial manslaughter. So if any negligence is discovered, this is where that legislation will kick in. The three key things that I've highlighted here in green are around criminalising wage theft, regulating the labour hire arrangement orders, and you will have heard of this as the same job, same pay legislation, and this enhancing of union delegates' right of entry and access. And we did a little session on that last year around worker consultation and union engagement. And so if you need to go back and review that, then also that webinar will be available on the website. So just a note about wage theft, those three key things. That offence will apply to employers who intentionally engage in conduct that results in the underpayment of their workers, including intentional underpayments of superannuation. So it was, I think it was the Greens and Jackie Lambie who got that superannuation included into that. Small businesses are excluded from that issue around superannuation, I think. The offence will carry a maximum of 10 years imprisonment. Okay, so it is a criminal offence, and there will be some fairly considerable fines. So these two seem very contrary. So 3 times the amount of the underpayment, and the person affected will have some say in this. for individuals who are found guilty of the worst kind of offences, $1.5 million, and for body corporates, $7.8 million. So you can see how serious the government is about wage theft. So be very sure, and this will go when you're working with labour hire providers as well. This is why you need to be extra cautious, because these these types of legislative provisions now exist. The same job, same pay provisions. This applies to labour hire workers who work for a host employer with an enterprise agreement in place. So there is a 3-month exemption that recognises a surge, potentially in our industry that there's a surge at a peak at a peak time in harvest, but it is a 3-month exemption. And the first industry that comes to my mind is bananas. So if you are a large employer with an enterprise agreement in place that provides for a higher rate of pay or classification standards for direct hire employees, that is the employees that you directly hire, then if you then use a labour hire company to bring other workers on through that labour hire company, your obligation then, if your harvest period is longer than 3 months, will be to ensure that those labour hire workers are also paid the same as those direct hire workers would be paid. So that is, if they're doing exactly the same job as one of your direct hire, and one of your direct hire is paid higher than, for example, the base award rate, then that enterprise agreement rate will apply. Now, this is subject to orders being made by the Fair Work Commission. So what happens is that a labour hire company or an employee can make an application to the Commission to make an order for that to occur. So it's not a simple process. It's not just a case of, making a phone call and getting someone to do it. It actually requires those orders to be made. It is restricted at this stage to employees operating businesses operating under an enterprise agreement. So there will be some impact, I suspect, or potentially some impact on our larger employers who do have enterprise agreements in place. And it's really going to be important that you seek some professional advice about the potential for this to impact on your operations. So again, bearing in mind, if you've got an EA in place, if some of the rates provided in that are higher than the award, if you're bringing in labour hire workers who are doing identical jobs, is there a potential that an order could be made for you to pay those higher rates? So again, we ask you to think about it prior to it happening in order to do some planning around it. Okay, the right of entry. Pardon me, this is really about officials assisting a state or territory. So that is a workplace, pardon me, work health and safety representative. So this exempts some people from holding a permit, so to assist a workplace representative. So if they, for example, ring their union rep or, a workplace rep or whatever to help them with an issue, this exempts those people from presenting a certificate. It is not clear to me why this would be the case, assuming that the majority of union delegates and work health and safety will have entry permits and the relevant certificates. So this one is a bit weird. We'll be pulling together full advice around right of entry. We did a webinar on this last year. Again, if you want to revisit that webinar, that's also available on the website. And you'll be able to just revisit those right of entry laws. So these are just, as I said, some minor changes, but are worth noting what you need to be, aware of. When we talk about workplace delegates' rights, we're talking about an employee. So we're talking about an employee who is appointed or elected under the rules of a union or an employee organisation, pardon me, and who represents members of the union in the workplace. Now, does this include a union official? Yes, it can, because those people are appointed to represent the interests of workers if those workers are covered by that union. And when we talk about workers now, we're talking about workers and potential workers. So the changes mean that those workplace delegates are entitled to represent the industrial interests of members and potential members of the union, including in disputes with the employer. So if there is a person at the workplace who is appointed as a workplace delegate, a union delegate, a shop steward, whatever term you want to use, they now have set rights. And there will be a model clause developed by the Fair Work Commission and inserted into awards around this. And I expect that that will happen sometime around the middle of the year, if not earlier. So they're allowed to represent the industrial interests of members. They're allowed to have reasonable communication with their members and potential members about their industrial interests, and they're allowed reasonable access to the workplace and its facilities to represent those industrial interests. So if a union rep at work comes to you and says, I want to have a union meeting of employees, normally speaking, you would have that in non-paid time, so before or after work or during a lunch hour period. However, some delegates employed by non-small businesses, so larger businesses, and it doesn't take much, 20 employees, 15 employees, 20 employees, they're also entitled to have reasonable access to paid time. So those people who, have to use, who have to spend time to organise these things, have some entitlement to paid time to organise those meetings. So during the normal working hours, because they're now saying that this work is part of their normal work. It's part of their normal job, is to actually represent the interests of the employees. And so therefore they need to have access to facilities, access to communication mechanisms with those, and access to management in order to discuss any concerns or industrial, disputes or interests they may have. Now, in doing this, there's some rules for employers around you cannot reasonably fail or refuse to deal with the workplace delegate. So if someone comes to you or someone is nominated as a workplace delegate to represent the workers at the workplace, you cannot reasonably fail. If you refuse to, cooperate, there will be penalties or potentially penalties that can apply. You can't knowingly or recklessly make a false or misleading representation to the workplace delegate, so you can't lie about things that may or may be happening. And you cannot unreasonably hinder, obstruct or prevent the exercise of the rights of that workplace delegate. So again, if they're asking for use of the air-conditioned meeting room in the middle of summer to, during the lunch hour to have a meeting, don't tell them they can meet under the tree or under the hot sun. We talked about how to operate in a cooperative fashion in our worker consultation and union delegates webinar, so you can revisit those webinars for details around this. Okay, and again, a reminder that all employees and independent contractors are free to choose to join or not join a union. This is known as freedom of association, and Fair Farm members will know that freedom of association is an integral part of our code of conduct. So it is illegal for a person to pressure another person about their choice to join or not join. So employers can't pressure employees and businesses can't pressure contractors. You cannot take or threaten to take adverse action for being or not being a member, or for taking part in industrial activity. So for attending those meetings, for example, or for choosing to be represented by a union. An adverse action might include dismissing, refusing to employ, changing their role, putting them in some kind of detrimental position, or discriminating between them and other employees. Reasonable access. Sorry, I just saw that question there. Look, reasonable access is, I mean, they don't define reasonable other than what would a reasonable person reasonably expect. So if a union delegate or a workplace delegate comes to you and says, I want to call a meeting of union members and potential members during our workplace. We want to access the lunchroom, or we want to access, the shed, or we want to access some facility, we'd like to have use of a laptop and a screen if you have it. We will be 20 minutes, that's it, tops out of the 30-minute lunch break, and then everybody will go back to work. So we're done in paid time. I will need an hour off to prepare this or, whatever. That is a reasonable request. And the question then is, would it be unreasonable of you to refuse such a request? So it works both ways. What is reasonable, but what would be unreasonable? So, use kind of common sense and think about it. What would be reasonable under those circumstances? So just a reminder, obviously your employee, and the reason I kind of raise this is, unions are going to have a lot more right under both awards, enterprise agreements and the Act until such time, potentially, as the government changes and we wind it all back again. But for the time being, at least, there will be enhanced rights. Now, I don't know if that means that you're going to be, that you're going to have lots and lots of visits from unions. I don't actually know what it means, but what it means is that when they do come calling, it's really wise for you just to be prepared, have the knowledge in the background, understand that you're best to approach it as cooperatively and collaboratively as you can, and that if you treat your workers fairly and reasonably and pay them correctly, then theoretically there should be no disputes. But again, pre-warned and forearmed is forewarned. Okay, so, and there we have it. It talks about here, we talk about, setting up a consultation framework with your workers, whether it's formal or informal, toolbox meetings and the like are fine. Something that allows you to get face-to-face in front of your workers, tell them what's on your mind, get them to tell you what's on their mind. Ensure your consultation is regular, authentic, targeted and two-way. There's nothing worse than one-way. This is what's happening. We're just here to tell you what it's going to be. I mean, obviously, you have the right to do that, but if you can get your people on board, all of that will run a lot smoother. Elected work health and safety representatives, remember they're entitled to have paid training and they have specific duties within the legislation and as part of their role at your workplace. So always recognise those roles, and now similarly with union delegates, know the rules around that freedom of association, right of entry, and just prepare and consider your approach. So those guidelines are always useful to consider should that eventuality arise. Okay, so moving on, stage 2 of, pardon me, the Closing the Loopholes Bill. There's a couple of things here. The Fair Work Commission is to set some minimum standards for employee-like workers. Now, those are the gig-like workers. So what it proposes is to introduce protections for this kind of new category of worker, an employee-like worker. These reforms are fairly significant. These employees who've never really been subject to any kind of regulation, largely being considered to be independent contractors. Obviously, the larger those groups of workers become, the less likely they are to be operating as independent contractors. So it, in essence, captures those contractors working in the gig economy, digital platforms, Uber, Deliveroo, those kind of things, and also the road transport industry, interestingly enough. So delivery drivers, non-employee truck drivers, rideshare drivers, etc. So they'll be looking at contractual terms, unfair terms, etc., etc. Workers have a right to challenge unfair contractual terms. So again, where they may have been employed as an independent contractor, there's a question around whether or not those contracts are legitimate and whether or not those people should not be more properly employed as employees. There will be a new definition for casual workers. The proposed definition allows consideration of the practical reality of the employment relationship. So what's actually going on, rather than just what was stated up front at the beginning of the employment contract. there are some civil penalties related. Sorry, I've just got an itchy nose. There are some civil penalties, and they're very high, okay, related to the sham contracting arrangement. So anything to do with unlawful job advertisements, employee records, misconduct, all of those kinds of things, the penalties have been increased fivefold, which means maximum penalties are almost up to $1 million now. So they're getting serious about sending these shots across the bow. There's not too many businesses, you know, who are going to be building $1 million up to $7 million penalties into their business model, which some of them certainly used to be able to do with $10,000, $20,000 fines. There's the strengthening of right of entry to investigate underpayments. And the Fair Work Commission is preparing model terms, as I said earlier, for union delegates. So those are things that are all coming, and we will be providing updated information along when those things become available, and it's potential that one of the next webinars, if not the February one, maybe the March one, we'll come back and update you on, you know, what's actually come through with those. Okay, while we're in update mode, I thought it was also useful just to go back and have a look at some of the webinars. You may not have been here for all of them last year. So very quickly, I've just realised I've hit 12:30. Very quickly, in 2023, we looked at all of these ones here on the screen. So we wanted to remind you about the policies around social compliance. Ethical compliance as a concept includes, you know, employment, work health and safety, and those kind of social aspects around management of dispute and freedom of association and discrimination and bullying and harassment. Diversity, equity and inclusion also come into social compliance. So it's a reminder to ensure that you have your comprehensive, your complete set of social compliance policies, codes of conduct, etc. in place, apropos of our last year's webinars. Again, the family and domestic violence leave, just familiarise yourself with the provisions, ensure that your managers and supervisors are trained and that they understand what their obligations are should that situation arise with them. Remembering that payslip details cannot include any reference to this leave. You need to come up with another code for that leave, whether it's full-time hours 1 or whatever. Remembering that you have to undertake full due diligence with your labour hire providers, particularly in those states where there's not licensing available. You need to ensure that you're only operating with legitimate operators and that they are paying the workers according to all of the awards. You need to have written agreements with those people in place. Do not operate with labour hire providers without them in place. They will provide you with some degree of protection, if not all of it. And you also have an obligation to monitor those labour hire workers on site. So tap them on the shoulder from time to time, ask them what they're being paid so that you can, check that against the pay information provided to you by the labour hire provider. A reminder around the sexual harassment provisions, that it's prohibited in connection with work, that it covers a whole heap of people, and that the employers are now required to take positive steps to ensure sexual harassment does not occur in the workplace, and that will include making a statement about zero tolerance. That will mean making a statement about we will, investigate complaints of this nature. That will be commitments to privacy and confidentiality and the like, and to working with employees to resolve any of those disputes. Bearing in mind that the Fair Work Commission is now empowered to resolve disputes. If you cannot settle them at the workplace and the employee determines to take that issue to the Commission is empowered to settle that dispute, which could include compensation for the worker. So check your policy and procedures to ensure that they make and include those positive statements. And again, train your managers and your supervisors and your workers around those requirements. Heat stress and sun safety, we did this one towards the end of last year. Again, just make sure that you've got your work health and safety in place and that you're looking after your workers. Hats, shirts, sunscreen, water and plenty of rest in this type of humidity and heat. If you go back and look at that webinar, it has the heat and humidity scale up, which shows you that, 20-degree heat with 80% humidity is equivalent to 33% heat or something. So go and have a look at that and make sure that you look after your workers. A gentle reminder about emergency planning. You need to test these procedures at least yearly. So if you do not have emergency planning procedures in place, please make it a priority to get them in place, and every year do a test run a mock emergency, like a fire drill, and one of the requirements is to have everybody sign the sheet at the end of that fire drill, so that you've counted all your heads against a list of workers on the day, and that you've made sure that everybody is accounted for. That will be looked for by an auditor, by the way, if you are facing an audit coming up. Records of the testing, etc., as we've said. Resources, look, again, there are some great resources. There are multiple resources available to you, but I guess I'd like to acknowledge where we get most of our information from, the Fair Work Commission and DUA. But also I found particularly useful Herbert Smith Freehill's summary of the legislation and Maddox Closing the Loopholes Bill, the Key Considerations Bill. And I just want to acknowledge and thank that expert work that's available. That's how we provide you with the information. I don't make this up, I can assure you of that. A quick word about Fair Farms. We know what it is. It provides that pathway to third-party benchmarking, but we've got some changes happening this year. We know the benefits. I'll come back to those in a moment. We are now introducing a non-audit pathway. So it now provides a pathway for growers who are not required, e.g. by their buyers, to actually be audited, but who nonetheless want to be able to demonstrate their compliance with the legal and ethical standards. So we have this new non-audit pathway available to Fair Farms members. And we'd certainly, you can then convert to an audit pathway should an audit be required, and that will put you in a very good place to undertake an audit, because it will take you through the online self-assessment activity and the training activity. Labour hire providers, we're also going to invite labour hire providers to join us at Fair Farms. What we want to be able to do here is to provide a consistent approach. We want to ensure that the standards that we uphold of our growers and that are expected by, our buyers and by government and various other stakeholders are also met across the industry by our supply chain. So from the middle of the year, or March, I think, labour hire providers will become able to become full members of Fair Farms. Version 3 of the new standards, these are reviewed every year to ensure that they meet the legislative requirements, etc. So the version 3, I beg your pardon, is now available on the Fair Farms website under resources. As I said, our current website is still there. It's under review, so watch out for that new design coming soon. Something really, really exciting that we're really, really proud to announce is we're introducing Fair Talk with Fair Farms. It's a 30-minute interview style presentation with Amanda Higgins, our workplace relations specialist, and it's going to be discussing a variety of topics in this kind of fair farm social compliance space with experts in the field. Our first speaker on the 7th of February is Steve Dargaval, who is the Labour Hire Authority Commissioner in Victoria. And Steve's job is protecting workers from exploitation and improving the integrity and transparency of the Labour Hire Initiative. There is a link there, so if you do go onto the website, or when you receive, you will receive a link to this webinar. So when you receive that, you can click onto that link and join, sorry, not that webinar. You will be able to link to the registration for Fair Talk, is what I'm trying to say. I'm so excited I can barely get the words out. Okay, just a reminder that we've got the Fair Farms Manual. Again, that's a comprehensive set of resources for growers, but it is only available to Fair Farms members. So if you're not already, you can join us through the non-audit pathway, and then you can purchase that through our normal things. Okay, I apologise for being 9 minutes over. We had a fair bit to get through. There was a lot that happened last year, and I just wanted to try and make sure that people were up to date. Our next topic is to be confirmed, depending on how this stuff happens in coming months with the next section of the changing the loopholes legislation. Okay. Thank you again so much for joining me. It's great to see you all on board in 2024. I wish you all a fantastic year, fantastic seasons, brilliant weather, and please join me on the last Wednesday of February for our next webinar. In the meantime, take good care. Bye.